Oh, yes. Good morning. I am trying to find some information in regards to a case that's pending on your docket.
Okay, do you have a case number?
Yes, ma'am. The number is 24CR018579-500.
Okay, how can I help?
Yes. It's scheduled for the 12th of March for just a general appearance, but I would actually like to schedule my actual date for a hearing on a court of record.
Okay, so that would need to be with the DA's office,
Mrs.
and I
Susan
can,
Doyle.
yes,
Okay. Quick question. I will definitely get over to her. I just wanted to ask you for the simple fact of the matter. It might be a question that's more directed to her than you, but
okay,
I would like to actually ask you, since you're the clerk of court, what is the actual market value on the case?
like how much is owed on it?
No, not how much is owed on the case. How much is the case actually worth as far as market value is concerned? Do you have that information on record?
I do not, sir.
Okay. All right. So I guess I have to go over to Mrs. Susan Doyle and have her fill out a Form W-9. Is that all right if I can support that for record?
Yes, sir, that would need to be done through her office.
Okay. I will definitely do that. Thank you very much.
You're welcome.
All right. Take care.
All right, and you too.
All right. Now, people, as I proceed, this video is not for children, nor does it constitute legal advice. Of course, I couldn't say that in the beginning of the video for the simple fact of the matter is that I was on the phone with the clerk. Now, please do not actually give me that information, although they can. But I just want to simply show y'all in real time, this is how you actually bring this up. Now, she's saying I have to talk to the district attorney, although it's a traffic ticket. Now, the title of this video, in and of itself, is called Admiralty Contracts and How They Operate Over You. In regards to this video, I want to show you that these individuals are basically combining a victimless crime and submitting it to the jurisdiction of a criminal court. What I'm basically showing you is that according to basically this phone call, because that was for a traffic citation, they're saying I have to talk to the district attorney. However, I had already done that and submitted documentation to the district attorney anyway. And since this is actually a court of record, of course I'm going to call the district attorney. I'm going to actually schedule my court appearance for a court of record, not general appearance. Now, for many people who may be asking, what is the difference between a court of record and an appearance? I'll tell you what for future reference. But this does not constitute legal advice. So just for general informational purposes, understand that when your case is submitted to a regular docket for appearance, once you receive a citation or a ticket, they're basically putting it on the record as if it's just a general appearance. If you want to beat a ticket and you want to actually have it on a court of record, there's a difference. When you appear for just a ticket, you're in court with just everybody. The judge can say whatever he or she wants because it's not on record. You have to specify whenever you deal with the court that you would like your actual hearing on a court of record. As you can just see, what I've just done with the clerk, I requested a court of record. I did not want to appear on the date that was actually prepared for just an appearance. You don't want that. If you want them to lack jurisdiction totally in the matter and not be held liable for any contractual obligation, i.e., traffic citation or ticket, you get it on a court of record. That way, you can enter things that have been already sent to the contending parties, i.e., the adversarial parties, and you can bring it to record that you have placed these things on court record and tell the court that they totally lack subject matter jurisdiction because there is no injured party. Now, me myself, I had already done my due diligence and I had already sent the actual district attorney an email. This is the email I sent. So, in regards to that, I already did my due diligence. She already got the email. So, in regards to this, if you want them to basically dismiss your case, you don't have to even worry about these people. You have to do your due diligence. Now, the case isn't even due until appearance for next month. But I can guarantee you it probably won't even go that far because in reality, they already know what they've lost. as you already noticed when I said something about the court remedy and the Form W-9 and so forth, which I already submitted in my email anyway, I already gave her a sent it to her. This is why you want it on a court of record and not just appear generally. Once you submit your documentations and they go unrebutted, there is no argument when you go to court. All you have to do is get it on record and you refer to it from the actual correspondence and the documentation that you sent to both contending parties, i.e., the arresting officer or the ticketing officer, I should say, which basically did arrest you, even though you weren't placed in handcuffs and detained, you were still arrested because your movement was arrested from furtherance in your private travels. So you send it to them. You send it to the district attorney. It's been well over 45 days. There's no controversy to the matter because I have received no rebuttal at my mailing address. And therefore, once I actually get the market value of this case from the district attorney, it is her responsibility to either dismiss it or I get the IRS involved via the criminal division. In discussion. It is what it is, people. And this is your court remedy in less than 7 minutes. Now, I know a lot of people, they don't show these things in real time. I'm using my life as I've been doing on my channel to show you that, yes, people, this is my life. This is what I do. Now, this is a practical matter. It's a victimless crime, but also it's also in a criminal jurisdiction. In order for any court to presume criminal jurisdiction, there must be an injured party. Now, I know most people be like, well, the state's the injured party. You cannot injure a state, people. It is impossible. Not to mention the prosecution, who will actually go over the case in regards to being the injured party, can't even prove it because she has no verification or any signed affidavit with a claim or statement saying she was injured. Total lack of subject matter jurisdiction will be dismissed, and I will get my recoupment in small claims court. For every appearance, I charge $2,000. For even being stopped, that's $2,000 as well. That's $2,000 against the attorney, and that's $2,000 against the actual prosecuting attorney. A lot of people say, particularly, you can't sue them; they have qualified immunity. But if you can prove fraud on the court, you can be entitled to damages, and they're not covered by immunity. Just saying, the more you read, the more you know. Stay tuned. Peace, light, love. And agents, fuck you. Simple as that. Take care. I'm out.